Cut across to our panelists this evening. At the back of the observations made by the top court of the country, I have with me Karuna Nandi, Senior Advocate, Supreme Court, Deshratan Nigam, Advocate, Supreme Court, Sanjay Hegde, Senior Advocate, Supreme Court, Jay Anand Dehadrai, Advocate, Supreme Court. And the question that we ask is very clear on what came off the top court today. What impact could this have on how freedom of expression and academic freedom is perceived in the country? I want to cut across first to Sanjay Hegde, Senior Advocate. Mr. Hegde, it's interesting with what the court observed today. And in that context, because, it seems that the Indian legal system is a bit of a potluck. You can go with exactly the same case or, the same charges, and you could get very, very varied and very, very different orders or judgments. And I'll give you a case, an example, maybe not for sedition, but for freedom of speech. If you actually look at Imran Pratapgarhi's case, which happened just about a month ago, one would hear that judgment and one would look at the observations today of the top court, and both coming in from the top court. And you walk away, I would think, very, very confused.
Well, that was a judgment. Today's is an order, and there is no judgment yet. Today, the court was confronted with a situation where the man was in jail for a social media post. There was no violence which ensued. Was it sedition? Was it not sedition? Is still a matter of investigation. What the court has done is appointed a new investigating team. It turned down the Haryana government's plea for some more time, because if it had adjourned the matter to Friday at their asking, Professor Khan would probably have been in prison for 2 days more, or God knows how long. So it has granted him immediate interim bail. Yes, just like Professor Khan's post could have been worded better, some of the observations of the court can be read in more than one way. But for the moment, what matters is that it has granted immediate bail to Professor Khan, and it has imposed certain conditions which are normal bail conditions. I would think that Professor Khan's team would be satisfied with getting their client out for today. The larger battle may follow on a different day.
But, Mr. Hegde, tell me something. The sheer fact that the court touched more on the timing of the post rather than the legality of the post, and that seemed to be made very clear, at least, in the order. What does it suggest?
Yeah, see, you were right about Imran Pratapgarhi and some others who got not only relief, but they got a large judgment in time. Unfortunately, the Supreme Court is a polyvocal court. Sometimes it's said that there are 17 courtrooms in the Supreme Court and there are 17 Supreme Courts. Yes, consistency, especially in judgments, is followed, but consistency in orders sometimes is the luck of the draw. I may have cause to disagree with what the court expressed during the course of argument, but then it's often a matter of tonality than anything else.
Fair point. Stay on with me, sir. I want to cut across right now to Jay Anand Dehadrai. Mr. Dehadrai, it's interesting because with what I said earlier, it seems to be actually potluck where the Indian legal system is concerned. And, why we bring up this particular cases, and I'll just give our viewers an example of what I was having a conversation with my colleague who covers courts, because it's the same bench that is also hearing the Tribal Affairs Minister, Madhya Pradesh, Vijay Shah's case. And in that case, A, they have given him relief from arrest, and B, there is no gag order on him from the court. On the contrary, you have a Professor Khan where there is a gag order and there is an interim relief, but the FIR is not quashed. So it's interesting because if you actually look at, what Professor Khan said and what the Tribal Affairs Minister said, one could think it's diametrically very, very different.
Preeti ji, good evening. And firstly, thank you for having me on your show. And I wanted to compliment you for your fantastic interview with Renu Bhatia yesterday, I think that was. And I think
Thank you, sir.
all of us, we really appreciated, your line of questioning and the patience with which you brought out a lot of very disturbing patterns of thinking that Ms. Bhatia had. So having said that, I think the Supreme Court today, Preeti ji, has taken an excellent decision. It is a balanced decision. The Article 21 guarantees a person's liberty, and I think that has been upheld today, which is very important. And here's the thing. Justice Suryakant, according to me, is an extremely sharp judge. And he alluded to certain double meaning, a possible interpretation that could have been made out of Professor Khan's statement that could have more than one meaning. And if you could have the same paragraph that you were in fact referring to yesterday, and if you would have that in front of you for a moment, and I'd like to play devil's advocate for a moment. If you see the last paragraph of Professor Khan's statement that he put out on social media, he talks about this illusion and allusion to an India that defied the logic on which Pakistan was built. And, he prefaces this remark with certain remarks about Colonel Qureshi. Now, why should we take away from the fact that Colonel Qureshi is a very respected, meritorious member of the armed forces? Why bring in her religion in this entire discussion at all? And perhaps this is what the Supreme Court was referring to today, rightly according to me also, to say that, look, if there is a question of investigation, let the investigating agencies have a go at it as well. But certainly in the meantime, they put a line of questioning to the lawyers who were appearing for Haryana and for the Union of India to explain what was it that was really offensive in his statement. So if you ask me personally, I don't find anything remotely seditious in what Professor Khan has said. I don't think there's anything wrong with it. It's his personal opinion. Yes, in terms of tonality, timing, and these are also factors that a constitutional court has to be alive to, which they were today, I think, and which is why perhaps the Honorable Supreme Court brought up this aspect, that why bring it up right now when India is going through a crisis. But having said that, I think insofar as we are, as we are concerned today, as Mr. Hegde also, I think, very rightly points out, it's only an order, it's an interim order. There is a line of questioning that the Supreme Court often, puts forward. It doesn't reflect their final view. And they are trying to elicit some answers from the counsels appearing for the various parties. So insofar as this is concerned, I think this is where we are right now. I think it's a correct decision to grant him interim bail.
Ms. Nandi, I want to bring you in because, I would reckon there is, and correct me if I'm wrong because you're 4 legal experts, that there is a fine line between tonality and legality. And I would reckon the courts should, read legality then tonality. And the second part of it, with what Mr. Dehadra has said, if you hear what Justice Oka said, when he was hearing Imran Pratap Gadi's case, leave alone that, just today, Justice Oka, when hearing a case on sedition, actually made it very clear that ideology cannot be seditious. It has to be action. Intent cannot be seditious. It has to be action. If you apply all of that to this particular observation, and I don't know because, we are not criticizing or attaching motive to anything, but I'm a tad bit confused.
I think your question is a very sharp question, which is that why are we looking at tonality rather than legality? I think the thing to remember is that sometimes in the recent past, in fact, we have had a number of Supreme Court orders, judgments. Maneka Gandhi is one example of that, the judgment, where you have a lot that is said, but the relief is not granted. Right? So today we have a situation where rather than issuing notice, rather than keeping the man in jail for 2 additional days, rather than saying, look, you go back to the High Court, the Supreme Court today has, for a petitioner that went directly to the Supreme Court, has granted interim bail. This is not a small thing, right? Umar Khalid didn't get it, a number of other people didn't get it. Of course, this is a very different case because this is a speech offense on the face of it. But I think you're right to raise a few questions, perhaps born out of your reading of former Supreme Court judgments in cases like Rangarajan, for example, right? That says that the speech must be a spark in a powder keg to fall foul of criminal provisions and to be accused of disrupting public order. Even if we take the situation and the surrounding context to be one of war, was Professor Mahmoodabad's speech that spark in a powder keg? Perhaps not. In Shreya Singhal, for example, the court said information that may be grossly offensive or which causes annoyance or inconvenience is still protected and innocent speech. A person may discuss or even advocate by means of writing disseminated over the internet information that may be a view or point of view pertaining to governmental, literary, scientific, or other matters, which may be unpalatable to certain sections of society. And that may be grossly offensive to some. It is still protected speech. Today, we have the man is out on interim bail. I think that is the main thing. This is only an interim order, and it's the first hearing. In the Ranveer Allahabadia case as well, the order was modified. And let us also remember that the gag is only on speaking to the particular issues that emerge from this case. So the gag is not more expansive than that. So in view of Rangarajan, in view of Shreya Singhal, there is the hope that the court will modify the order that has been passed today with regard to the conditions as the case moves forward. But we also must remember that the process is the punishment.
Ms. Nandi, in all of this, other than just a gag order on, Professor Khan on not speaking, writing about his case or Operation Sindoor, there is also a message, a larger message, which comes in for private university and students, that they should not get into doing anything wrong or saying anything wrong. What do you make of that? Where you juxtapose it with freedom of speech and expression.
So a lot of things are said in court which don't find their way into orders. That comment did not, as far as I can see, find its way into an order, right? For better or for worse, these things are now live streamed. And I think that there may be a bit of a lag between the live streaming and judges then being more specific about what they are saying with regard to the case.
All right. I want to bring in Desh Ratan Nigam into this conversation because, Mr. Desh Ratan Nigam, this is an observation once again. It's an observation where interim bail has been granted, interim relief has been granted. The quashing of FIR hasn't quite happened, and we want to give our viewers context to it because the hearing for that is only on Friday, which is the 28th. So that will happen later. So that wasn't even in question. But the sheer fact, sir, if such observations become precedents, then are we looking at a norm of self-censorship?
Well, Preeti, in fact, we do hear a lot of observations when the hearings are going on in court, which are not reflected in court, but they do give the intention of the courts. And certainly the FIR has not been stayed and the investigation will go on. And the very important word which is used is dog whistling. Dog whistling is a concept where coded messages are intended for a particular part, section, which others do not understand. So that is a very important thing. Issues like this war is taking place for the benefit of politicians and arms manufacturers. India is also an arms manufacturer. A number of homegrown systems were used in this particular, Operation Sindoor. So whether these are coded messages or not, they require, there is a deep complexity and also deep investigations are required, which is why an SIT has been created with a lot of impartiality because the officers of Haryana and Delhi will not be a part of the SIT. So those things have been taken care of. And also trying to give a communal angle and the right and left angle that only right wing was praising Colonel Sophia, which in my opinion was not the case. He clearly establishing himself as a leftist. So there are a lot of hidden and deep meaning out there, and this requires a deep investigation. Therefore, investigation has also not been stayed. And rightly so, yes, interim bail has been granted, certainly yes. And another important aspect is that rights and duties are coterminous. Rights are not, and it's a very important message. You don't forget your duties.
No,
also,
I agree.
I
agree, Desh Ratan Nigam ji. It's a very important message, and it can, like I said, be a message which could result in a fair amount of, like I pointed out, it's kind of chilling in nature because it will result in self-censorship, for many. But Karuna Nandi, you wanted to come in, and I'll go back to Mr. Hegde.
I just wanted to say that when a speech offense is indicative of something deeper, of something of a larger conspiracy. That's one issue. But when the speech offense is just being prosecuted on the basis of the speech itself, then perhaps the only thing that the SIT needs to focus on is the interpretation of words, like illusion and allusion. In fact, in the same court, we use the word allusion a lot because, this judgment alludes to, this paragraph alludes to, it means refers to, right? But should this speech indicate that there's some greater conspiracy? That's one thing. But if the speech is just being prosecuted because the speech itself was found to be offensive, then the SIT should just focus on the words and go back to the court and say, this is what we think the words mean. And this is the context. There was a conflict going on, and we thought that this wasn't right. And then let the court decide based on the slew of constitutional judgments, including Imran Pratap Gadi, that must guide it.
Mr. Deshratan, okay. Go ahead, Mr. Dehadrai, go ahead, and I'll go to Mr. Hegde after that.
Very quickly.
Can I just intervene for a second?
Personally,
each of you will get, I'll come to the both of you, whoever wants to go first. Mr. Dehadrai, if you want to go first, go ahead.
Thank you. I'll be very brief. Personally, I think Mr. Khan, of course, has all his rights in place and he can make whatever comment or opinion that he deems appropriate. But if you ask me, the tone and tenor of what he has said is extremely sanctimonious. It's preachy. It was unnecessary. If you look at one of the paragraphs where he says that those who are advocating mindlessly for war and so on and so forth. What was mindless about this skirmish that India had with Pakistan? There was nothing mindless about it. You had terrorists coming in from Pakistan, butchering innocent Indians. This has been happening for decades. And then finally, the Indian government decides to do something about it. And you have this gentleman sort of coming in and making this post. I'm not saying even for a moment that he doesn't have the right to say this, which is, I made that very clear in the beginning. I'm one of the first few individuals to have spoken out against his arrest. I'm not saying he should be kept in custody even for a moment. I'm not for thought crime. But the post and what the Supreme Court has said ties in very closely to what Mr. Nigam has said right now, that there may be a requirement for a larger investigation. Let it happen. Let there be an investigation. I agree with what Ms. Nandi also says very rightly, that often the process is the punishment. She's right. And nobody wishes that for him. But there could be elements and aspects of what he said that are deeply problematic.
That could be problematic because that's interpretation, Mr. Dehadrai. And that's interpretation. And interpretation is subjective. So that's where you come down to the legality of it or the interpretation of it.
I don't disagree with you.
So that's all I'm saying. It is subjective.
But one moment. If I may just say one more thing. I'm so sorry I'm interrupting you. But if I may just say one thing. You're right, it is subjective. But if you would kindly go to the last paragraph again. And this is the paragraph that deals with, this aspect about Colonel Qureshi's religion. It is really, he is alluding to the fact that she is Muslim and therefore the right wing, which he of course refers to only as Hindus, should, somehow speak out against these supposed atrocities being committed against Muslims. What does he mean by that? And he also refers to, the two-nation theory and why Pakistan was created as a theocracy. Is he therefore suggesting that India is also now veering towards becoming
But that's interpretation, Mr. Dehadrai. All of this is in the realms of interpretation. No, he's not saying that. You're interpreting it as that. I want to just, I'm going to come back to you, and I want to allow me to.
Meaning, that is honestly.
But sir, that's how you've interpreted. That is possibly your interpretation of it, because he's saying what he's saying. You need to take that.
We can agree to disagree with each other, but this is how I'm reading it.
I'm not even agreeing or disagreeing. All I'm just saying is this is not what he's saying. That's your interpretation of it.
Very well. Very well.
Okay, allow me to go back right now. I want to bring in Deshratan Nigam has a point. You wanted to come in for a counter, and I'll go back to Mr. Hegde and Karuna Nandi. Make your point, Mr. Nigam.
The fact is, what SIT should do or not do will be open to them. When an investigation happens, though, they check the entire background, the past records, whether something has been done in the past, and they try to build the chain of events to the present. And this is how investigation go on. They may not be only focusing, as suggested, only on this particular Facebook post. And secondly, the concerned professor clearly forgot the massacre at Pahalgam was on the basis of religion, where Hindus were massacred by Islamic terrorists. He clearly, undermines all that and wishy-washes that. So there is an intention which can be, gleaned out of this entire issue.
But what is the intention? I fail to understand that. But having said that, I'll come back to you, sir. I want to bring in, Mr. Hegde and Karuna Nandi back into this conversation because Mr. Hegde, I'll hark back again, like I said, to what, at least on the basis of freedom of expression, was said on Imran Pratapgarhi's case. Because when you look at the verdict, you think that's a landmark verdict which safeguards freedom of expression and academic freedom in this country. On the other hand, if I look at the observations, and once again, these are observations as interim in nature as they can be, but the messaging is very clear because the top court did use dog whistle. Dog whistle clearly seems to suggest, I would reckon, in this case, is malicious intent. So what is the messaging that goes down to somebody, who's on social media otherwise will now look at self-censorship at the cost of repeating myself?
Well, that is the danger that the Supreme Court possibly has fallen into. I see two dangers from what has happened today. Firstly, it will embolden the Renu Bhatias of the world, and every little tin pot dictator with a fiefdom will feel emboldened to go after everybody whose opinions differ with her or him, and say, okay, let's see in the police station, let me get you locked up by a friendly policeman, and you beg for liberty in the courts. That's one danger. The second danger is, as you said, of the chilling effect. All of us will possibly be self-censoring. And, in the words of Firaq Gorakhpuri, अब अक्सर छुप छुप से रहे हैं, बस यूं ही कभी लब खोले हैं, पहले फिराक को देखा होता, अब बहुत कम बोले हैं. So we will all be speaking less. And when you speak less, when you decide that there are certain topics with which you will not engage, then you will think less. We will be a nation of silent, nodding people. And that is the real danger. Freedom of speech is not required for popular speech. You do not need constitutional protection to say that the Prime Minister is a great man. You need constitutional protection when you think that your leaders have messed up, when you say that this has gone wrong, or that this country has made these following mistakes. Then, even if the world is against you, the judges of the constitutional courts, as sentinels on the qui-vive, have to come to the aid of the citizen who is being attacked. That is the job function. And sometimes I do not see that zealousness to defend free speech. We often get into these definitions of this is, you should not have said this. To again quote Rahat Indori, हमारे मुंह में तुम्हारी जबान थोड़ी है. So we have the right to say what we think and the right to think what we say. After that, if you find that it violates contempt of court, it violates defamation, or it violates any other law which has been validly made, please take me to court and go through the legal process. Here we have got the wrong end of the horse. You put the fellow in jail, and then courts think that we've let him out of jail. So the job is done. No, the job is to protect free speech and free unpopular speech.
All right, I'm going to give all of you, for your concluding comments. Let's begin with Deshratan Nigam. Go ahead, sir. Make your final comments.
Well,
on how it impacts freedom of speech in this country. Yes. Go ahead, sir.
The freedom of speech, as we know, right from our constitution to the Supreme Court judgment, is not absolute. Yes, unpopular speeches may be there, but it should not be anti-India. It should not be anti-armed forces. It should not be anti one particular community. That is where the red line is drawn. And if they are unpopular, at the same time violate any law, they have to be taken to the task. and therefore you cannot, make exceptions on the basis of the fact that incitement is going on, a particular community is being targeted, a society is being clearly divided on the basis of left and right in term for Colonel Qureshi. So these are the very important factors that the courts keep in mind, not merely that it's a merely unpopular speech. Nobody, touches if it is merely unpopular speech. I think our courts are matured enough to make that distinction between unpopular speech and speech which is anti-India or violating any law.
Nobody is doubting one's, intent or the maturity of the courts. But I would reckon, I think it's safe enough to question that at one end, the same bench doesn't give, a gag order to the tribal affairs minister in Madhya Pradesh, and yet you've asked the professor, schooled him at that, and that's the better judgment of the court on what he should and should not have done and the timing of it all. Final comments, Ms. Nandi. Go ahead, ma'am.
I think that our government's decision to go to to take action against the terrorists' shootings in Pahalgam was a very salutary one. It was a very important thing to do because clearly Pakistan has not been able to deal with it, and the time had come. The point is that should someone disagree, and should someone not just be advocating for peace, but should someone also be saying that something that so many of us found wonderful, that Colonel Qureshi and Wing Commander Vyomika were representing us when we were being told and being updated on what was going on. Should someone raise that as a good thing, but also say at the same time that let us not forget in the larger context that there is impunity with regard to lynchings, etc. We must remember our root values in our constitution. And in Shreya Singhal, citing this judgment with approval, the court has said that order cannot be secured merely through fear of punishment for its infraction. It is hazardous to discourage thought, hope, and imagination that fear breeds repression, that repression breeds hate, and that hate menaces. And so, therefore, I do think that this order is what it is. It came in the wake of the SIT being set up in the case of the Madhya Pradesh minister.
Fair point.
And so perhaps some even-handedness had to happen, but there is room for modification.
Okay. Mr. Dehadra, final comments.
Very quick. I'll be very brief. Just three things. One, I think the court today acted with fantastic maturity. India has a complex demographic fabric, and I think sometimes the court has to be alive to certain sensitivities that might get offended. So I think the first things first, I think what the court today is absolutely right. Second, I disagree with great respect with Mr. Hegde. He is entitled to his view, but I wish he would not take such a pessimistic view of the things that are happening in India. This is the same country in which the Supreme Court also acted with great speed and has released this gentleman on the same day. Plus, the NHRC has also taken notice of Professor Mahmoodabad's arrest. So there is no need for him to feel so pessimistic about what is happening in India. I think we all, especially him, I think his freedom of speech is irrepressible. He's known to say things that are on his mind. So I think that's not fair. And third, personally, I think what Professor Mahmoodabad has said, it could have perhaps been avoided. He's taken he's become a martyr now for no reason. And I don't agree with what he said, but certainly does this amount to sedition? Certainly not. And I think Renu Bhatia should be brought to account for what she has done. What she's done is a crime, and I want to say this, and I think she should be prosecuted, for malicious prosecution for going after this person.
I just want to bring in Mr. Hegde, final comments, and then I need to close the show.
You see, this question of timing. In wartime, do you shut up or not? Long ago in 1948, Lord Atkins said, in this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. So if you have a right during peacetime, you have a right during wartime also. Yes, citizens have good sense, but otherwise, you cannot go after citizens just because you dislike what they say in sensitive times. you are doing no justice to this country. And people like me tend to get pessimistic the more that thinkers end up getting punished.
Okay. All right. I appreciate all four of you for joining us. Thank you for taking the time out. We're going to leave it for the better judgment of our viewers to decide on which side do they stand on. Because, you know, what it looks like, viewers, it's a bit of a potluck, the Indian legal system. You could go in for the same case through the top court and get very, very diametrically different judgments. In this is only an observation. And Professor Ali has interim bail. The case is now going to be heard on the 28th. Thank you for joining us.